RC and co-lawyers provide services in the subfield of strata and subdivision. In this subfield of law, our firm provides guidance to owners corporations, residents and service providers on matters relating to owners corporation disputes. Guidance is provided through legal advice and representation in tribunal or court hearings. We also provide guidance by attending and communicating with the relevant stakeholders in that industry. If you have any questions in relation to complex strata and subdivision matters, please do not hesitate to contact us at RC and co-lawyers.
Good morning, Strata enthusiasts. Welcome to Live Breakfast with Managers Strata Law Week. I am Ria, here to present the host of this morning's live stream, Rochelle Castro, Strata lawyer.
Good morning, all. Welcome to day 2 of 4 of Breakfast with Managers Strata Law Week. It is December 1. And that means that officially the changes to the Owners Corporations Act and Owners Corporations regulations have now taken effect. We will now continue with the changes to the Owners Corporations Act. Let's get down to it. Slides up. Next slide. So today we will be tackling parts 4 and 5 of the amendments to the Owners Corporation. The first part, we will focus on the meetings and decisions of the Owners Corporations, particularly focusing on the first meeting of the Owners Corporation, annual general meeting, special general meeting, the procedures in those meetings, ballots, proxies, and powers attached to that, including the decision of the Owners Corporation. We will also be discussing committees. Next slide. Section 67A now provides and is now taken effect what states as what should be disclosed at the first meeting. And that is officially after the plan of subdivision is registered and when the owner or owners get together at their first general meeting. So subsection A provides that at the first meeting of the Owners Corporation, the developer or the initial owner or the person who has applied for the registration of the plan of subdivision must disclose the following: any relationship with the manager of the Owners Corporation, any immediate or future financial transactions that will foreseeably come out or arise out with the manager of the Owners Corporation, and any specific benefits that flow from that relationship. Next slide. Further disclosures relates to the contract being entered into by the applicant for the registration of the plan of subdivision before the first meeting. If the developer appoints a third party, which is usually the professional manager, before the first meeting of the Owners Corporation, the contract of appointment of that manager appointed by the developer expires at that first meeting, which is a significant amendment to the Owners Corporations Act, in my view. Section 67B subsection 2 says that if the developer or the initial owner of the Owners Corporation enters into another or any other contract in addition to the contract of appointment that relates or affects the Owners Corporation and benefits the developer or the initial owner, any term of the contract must not exceed 3 years in duration. So this is not only the manager's contract, but also any other contracts that have been entered into by the initial owner, unless the term is in a contract that is a hotel or resort management. So there's that, those industries or those types of properties are not affected by this particular provision. So there is a clarity in subsection 3 where the third party manager means a person appointed as the manager who is neither the developer or a lot owner of the Owners Corporation. Next slide. Further changes. Section 67C relates to the minutes of the first meetings of the Owners Corporation. The Owners Corporation in subsection 1 says must arrange for minutes to be kept of the first meeting. That's nothing new, but it's just really expressing that the first meetings should be kept in custody and a copy should be retained. The minimum information to be recorded in the minutes of the first meeting is information referred to in Section 81, subsection 2, which are the details of the items in a general or annual general meeting. Any disclosure made under Section 67A must be recorded in the minutes of the first meeting as well. And that relates to benefits, that relates to any manners that usually trigger contractual or financial obligation that ties the owners' corporations up as a result of the developer's decisions or contracts signed prior to the first meeting of the owners' corporation. Next slide. Section 36 lists the obligations. That's now inserted as Section 68 subsection 4 in the Owners Corporations Act, subsection 4A in particular, which provides that the developer or the initial owner of the owners corporation or any associate must not be appointed as the manager of the owners corporation. This is nothing new to other states who have in the past few years amended their respective Strata Act. This is simply Victoria following through in respect of this provision. So this keeps the developer from appointing themselves as manager, or vote on any resolution of the owners corporation that relates to a defect in the building of the plan of subdivision. So this then gives protection to the incoming owners or purchasers who have purchased off the plan to get protected in the event that there is a defect in the building. They're able to pursue the developer or the developer's associates. Next slide. Subsection 4B says that the developer affected by an owners corporation, so this relates to the developer, must not propose an annual budget of the owners corporation that is unreasonable or unsustainable. This then protects the consumers to make sure that when they buy into and off the plan, they are coming in without having to be shocked with having to increase the budget of the owners corporation. So it's more a realistic and sustainable way of a new owner coming in to buy to a development that is affected by the owners corporation. Further, the developer must not designate as a private lot what normally would be common property or services. This then avoids the developer from assigning a particular lot for their use. The developer must not receive any payment from the manager of the owners corporation in relation to the manager's contract of appointment. So this then avoids as well any benefits, financial benefits that is exchanged between the manager appointed by the developer and the developer. Next slide. A new Section 78 subsection 1 of the Act provides that subsection 1B and 1C below, the manager of the OC may pass an interim resolution at a general meeting of the owners corporation if no lot owner is present, whether in person or by proxy at the meeting. This then allows a smooth and continuous operation of the owners corporation. This is something new. In the event that a manager is not given a proxy or no one shows up at the general meeting, this provision, Section 78, subsection 1, allows the manager to proceed and pass interim resolutions at the general meeting. Subsection 1B says that the manager must not pass interim resolutions that affects their contract of appointment, that involves an amount that is greater than 10% of the annual budget of the owners corporation. So that means that there should be not more than an increase of 10% in the annual budget, or if the annual budget has not been set for the relevant year, involves an amount that is greater than 10% of the annual budget of the OC the year before. That's subsection C. Subsection 78(1)(1)(c) provides that an Owners Corporation Act by an ordinary resolution may exclude or alter the power of the manager to make an interim resolution under subsection 1A. So there is a limitation mechanism that the Owners Corporation could use. Managers should just take note of that. And to those viewers who are not managers, take note of that particular provision. The amendments have given that entitlement. Next slide. Section 89 relates to voting on a resolution of the OC at a meeting. Subsection 1 says that subject to subsection 3, and I'll refer to that shortly, a person may vote on a resolution of the OC at a meeting by show of hands. So this is nothing new. They could raise their hand up or any other prescribed matter unless the meeting resolves that it be voted upon in another way. That's nothing new. Subsection 2, any matter other than the matter requiring a special or unanimous resolution must be determined at a meeting by a simple majority. That is also nothing new, subsection 2. Subsection 3, at a meeting, a lot owner, and this refers to general meetings, either in person or by proxy, before or after the vote is taken by ordinary resolution, may require a poll, and this would be counted on lot entitlement. That is also nothing new. If voting on a poll under subsection 3 must be a written vote, the usual. If a poll is required after the vote is taken, the decision on a matter determined by a simple majority cast at the meeting has no effect of the decision on the poll on that matter, but it should be decided upon the poll. And subsection 6 is what is added, clarifies the question. What are the different ways that we can hold? So a person who participates in a meeting by a teleconference or another prescribed matter is taken to be present in person of the meeting. This, in my view, allows for video conferencing. Next slide. Proxies, significant changes. Section 89C provides that a lot owner may authorize a person in writing to be the lot owner's proxy in the following capacities. They could attend, speak, or vote on behalf of the lot owner at the meeting. They could vote on behalf of the lot owner at a ballot. They could represent the lot owner on a committee of the OC. Subsection 2 provides that despite subsection 1C, a lot owner who is a member of the committee must not authorize a person to act as a proxy to represent the lot owner in the committee unless that person that they're giving the proxy to is a committee member. That is a significant clarification. In my view, it has always been practiced by those who understood what the previous act provided. Now this provides clarity that you can only give your proxy to a fellow committee member. Subsection 3, an authorization under subsection 1 must be in the prescribed form, authorized by an individual, and be delivered to the Secretary of the OC. Next slide. So let's continue. An authorization may set out how a proxy is to vote on a particular matter, so there could be written directions. Subsection 5, an authorization cannot be transferred to someone else. It could only be given by the lot owner themselves to another person. Subsection 6, it's good for 12 months or if an earlier date that is specified in the authorization or the proxy. Subsection 7, a person who is not a lot owner but who is a proxy of a lot owner may not vote on any matter that affects the person that relates to delegation of powers or appointment or payment of the removal of the manager. This is nothing new. So this usually impacts a person who is servicing the OC in making votes should a proxy be given to them. Subsection 8, a person authorized to act as a proxy must act honestly, in good faith, and due care and diligence. And the contract of appointment of the manager made in controversy is void unless it is. Next slide. So subsection 10 now provides that if a lot owner is in arrears of any amount of fees or any other amount owing to the OC, the lot owner cannot vote, which hasn't really changed from the previous legislation. Next slide. Restriction on the number of lots. So this is what impacts now proxies. The restriction is under section 89D. Subsection 1 provides that a person must not vote as proxy on a resolution of the OC on behalf of more than one lot owner if there are 20 or less occupiable lots on the plan of subdivision, or subsection B, on behalf of more than 5% of lot owners if there are more than 20 occupiable lots on a plan of subdivision. So these are significant changes to the proxy rights. There are now limitations, and you should note the number of occupiable lots. The magic number is 20. Subsection 1, according to subsection 2, says that it doesn't apply if the lot owners for whom the person is authorized to vote is a family member, or the person votes as proxy in prescribed circumstances. In my view, an example would be like a corporation if they nominate a representative to speak on behalf, or an agent of the corporation. Next slide. Let's move on to the next slide. Section 89E, in respect of revocation of proxy. A lot owner may at any time revoke the authorization of the proxy and vote at a meeting instead. So if they do change their mind, they could always take back the proxy. A notice of revocation under subsection 1 takes effect on the date that the notice is given to the secretary. So there is that notice of revocation that should be provided if the lot owner revokes the proxy. Next slide. In respect of the powers of attorney, this is mirroring what the proxies have. I'm going to take you to subsection 2, which is another way of giving a right to vote. So despite subsection 1, a person must not vote under a power of attorney on a resolution at a general meeting on behalf of more than one lot owner if there are 20 or less occupiable lots, or on behalf of more than 5% of the lot owners if there are more than 20 occupiable lots on a plan of subdivision. So this is simply a mirror of what the proxy limitations have. Let's jump down to subsection 5. If a person is authorized to vote on behalf of a lot owner under a power of attorney, this part applies in relation to that power, as if the person who holds the power of attorney was the lot owner. So it's similar, like what I said, in respect of granting the vote, making decisions on behalf of the lot owner. Subsection 3 says subsection 2 does not apply if the lot owner for whom the person is authorized is a family member. Next slide. Section 89H, terms of contract of sale limiting voting rights void, and we have seen this in the past, placed by developers. This now clarifies any limitation of the developer for incoming owners to vote. Any term of a contract of sale of a lot that limits or controls the voting rights of the purchaser of the lot is void. And so that means that where clauses in contracts of sale says that since you're buying this lot, you cannot vote against matters that relate to the developer, that is now void according to Section 89H. Next slide. Committees. Section 100. The change is now affected. The change is that Section 100 says that the threshold of committees now, owners corporations now required to have committees is 10 lots. So where there are 10 lots or more, the changes to Section 103 of the Act says that the committee must have 3 minimum members and a maximum of 7. That said, Section 103 allows for the owners corporation to grant 5 more seats on top of the 7 seats by passing a resolution. This usually fits the larger owners corporations. Next slide. That closes day 2 of Breakfast with Managers, Strata Law Week. We look forward to seeing you tomorrow, looking and getting down to further amendments to the Owners Corporations Act. I look forward to seeing you. This is Rochelle Castro, Strata Lawyer. See you tomorrow.